So let's get into the legal foundations for E&O. So this will be real basic, but really what you want to look at is what defines a professional. It's a specific talent, a livelihood. It really is more of an intellectual ability versus a physical skill. So a doctor is more apt to have a professional liability policy than a football player. It really comes in like an intellectual type of thing. You need specialized training, education, continuing education. So insurance agents is a perfect example of all of us have had education, we've all had training, and we all need CE to keep our licenses. Perfect example. And a lot of times for professional, there's licensing bodies, you're certified, it's regulated by the state and or other professional organizations. So examples of this, these are real common. If someone says, when I go in and I say I'm the professional liability product leader for USLI, without fail, people automatically think of medical malpractice, legal malpractice, E&O for architects and engineers, and they're all very common classes of things that definitely need E&O. There are other ones, and we're going to get into a bunch, but insurance agents without question, real estate agents, accountants, and really any type of consultant that when people rely on your advice to make decisions, you need professional liability. So on a professional liability form, it's always going to cover a specific service. It's going to say services as a blank, and this is where you have the opportunity to define what your client is doing. And usually it says fee. So for example, services as a management consultant for others for a fee is a very common description of operations. The key is that for a fee is very common. So you want to make sure that if for some reason your client is performing services but not necessarily for a fee, maybe they're a consultant but they're working for the church and they're doing it pro bono, you want to make sure that there's coverage for that. And you want to make sure that there's an endorsement in the policy to give pro bono coverage. So the real key with E&O, I'd say about 95% of the claims that I see always relate back to negligence. So negligence really is failure to perform a duty as subscribed. So in order for negligence to be proven, the following four things must exist. So there must be a professional duty. What that means is that you have a higher standard of care. You as an insurance agent are expected to know more about insurance than your neighbor who may be an arborist. So you're held to a higher standard of care. There's a breach of that duty or failure to conform to the standards of that duty. There's a causal connection between the conduct and the resulting injury. That's called proximate cause. So just because you're an insurance agent and you know a lot about insurance doesn't mean you're held to, you could be sued for anything that happens related to insurance. There has to be a reliance on the advice you give before a claim could be brought. And then that damage has to result to the plaintiff from that act, error, or omission of the defendant. So there has to be a proximate cause, a causal connection between the advice given and the damages. Presence of an implied contract and services provided. Okay. So next slide. It's real basic. A client relies on the expertise of a professional. Due to this relationship, the client can suffer financial loss. The key here is financial loss. Typical professional forms that are not endorsed do not cover bodily injury or property damage. That's what GL forms do. This is financial loss caused as a result of the reliance on some advice that's been given. There are a couple other non-negligence-based claims that you could see. First is more of a media exposure, but what you're seeing is a blend in media and E&O nowadays. And this is intellectual property. So intellectual property is more of like a trademark or copyright, a trade secret type of issue. An example of intellectual property, you may be familiar with like Adidas and Forever 21, where Adidas used the 3 stripes as their logo, and Forever 21 for years used 3 stripes on their clothing, and Adidas was upset about that and sued Forever 21 for intellectual property. So that's an intellectual property claim. How that relates to E&O, however, would be, let's say you're the advertising agency that is involved with developing that campaign, and say you develop Forever 21's campaign to focus on providing, using those stripes to promote their product. That's where E&O comes in. You were negligent in advising Forever 21 to go that route. And you see it all the time. You see people like Coke and Pepsi, and they have a ton of people that all they do is surf the internet looking for violations of their brand. And you just want to make sure that if you are involved in anything that's in the creative space, that you advise your clientele to have intellectual property coverage. So that's really your graphic designers, your tech people, your marketing consultants, your advertising agencies. Very, very important coverage gets neglected for a lot of people, intellectual property. There are other ones that come up in the E&O world. This is like violation of statutes. And really you'll see fair housing stuff, consumer protection law, maybe if you're a collection agency. So certain coverage forms will provide extensions of coverage for these things. It just really depends on the class of business that you're working on.